This morning I'm here with our personal injuries team. I'm Sam, beside me we have Tyla and Ivan. OSheaDyer Solicitors, we're a no-win, no-fee law firm, and our first appointment is free. One question that we often get asked is the process at which the workers' compensation claim progresses. Tyla, would you like to explain that process for us?
Sure. So when someone has been injured at work in Queensland, they often lodge a work cover claim. At the end of that claim, you are normally issued with what's called a notice of assessment. At that point in time, that's generally when a common law claim can commence. So we don't like to sit and wait for that to happen. We like to be proactive, and we have your section 275 notice of claims ready to go and lodged. Once that document has been lodged, the time starts to run, and the lawyers who act for Work Cover Queensland, they have 6 months in which to respond to that. Once that 6 months has run up, and sometimes even before that, we have to progress to what's called a compulsory conference within 3 months of that time. At that compulsory conference, we try to negotiate a settlement for your claim. Usually, if it settles, then that's great. If it doesn't, that's when it's time to start looking at the court process, which Ivan is going to explain for us.
So the court process is very prescriptive in the sense that once the compulsory conference takes place, we have 60 days in which to file your claim and statement of claim in the court. That's then served upon work cover and upon the employer. Work cover appoint their lawyers. They then have to file a defence within 28 days. Sometimes we will then file a reply to that defence. Once that occurs, the plaintiff, so the injured person, files a statement of loss and damage. The other side are then required to file a similar document. But at that point in time, really, your claim is ready to go to court. Before the claim goes to court, there would always be what's called a Rule 553 mediation conference. That's the last attempt or last opportunity for your claim to be resolved before it goes to court. Obviously, we do whatever we can to try and resolve your claim prior to court, but if insurance companies, work cover, if they're not being reasonable and not offering you the compensation that you should be offered, at OSheaDyer we have no problems taking claims to court if we have to. We want to get the best result for our client that's possible.